There are important dates in the life of a child, such as their birthdays or the day they join school and so on. For a child born in the UK to non-British parents and who have lived here for 10 years, the day this child becomes a British citizen is also an important day in their life. However, there are lots of children who cannot apply to be registered as British nationals because they cannot afford the Home Office fees. Continue watching for more. This is Kareesha Turner, your human rights barrister, bringing you law updates. This broadcast is part of a series that I will be doing on children immigration rights in the UK. In a decision that came earlier this month, the Court of Appeal has confirmed that the Home Office's fee for registering children as British citizens is unlawful. Nothing surprising there, if you ask me, as the Court of Appeal was simply upholding an earlier decision of the High Court. Many children born in the UK living here from an early age do not actually have British citizenship, but they can do so and can become British nationals through a process that we call a registration process. And the fee for that is £1,012, that's the Home Office fees. But if you have more than one child, the cost can be excessive. Most parents simply cannot afford the fee, and what we have is children growing up who are entitled to become British nationals are not doing so due to the fee. The court looked at how much it effectively costs the Home Office to process the applications. It was found that it costs the Home Office around £380, and the rest of that is profit-making business for the Home Office. Profit at the expense of children. The court also found that the Home Office was not looking or considering the best interests of children and when it came to such applications. Citizenship is important to a child. For children who are not born British, there is an entitlement under the British Nationality Act 1981 for such children to be registered as British upon application, obviously, and if certain conditions are fulfilled after their birth. The reality of it is that these children are schooled in the UK, have integrated, and at this age, they are probably they want to go on school trips with their friends, and want to live fully as British nationals. It's an important step in their lives, and most parents will agree with me. There are currently two provisions in law, section 1(3), where a child born in the UK who is not a British citizen is entitled to be registered as a British citizen if before they turn 18 their parents become British or settled in the UK. There's that. And there's also section 1(4), and many will fall in that category. A child born in the UK who is not a British citizen is entitled as a British citizen to be registered as a British citizen anytime when they turn 10, as long as they've not been absent from the UK for more than 90 days in any year. In terms of documents, there's a list of documents that the guidance mention, and I always advise my clients to go overboard with the evidence, and that's important. What about refusals? Well, I have heard that the Home Office has refused such applications before. At the risk of sounding cliche, what do you do when you have a refusal? Contact a lawyer or contact me immediately. Although the Home Office always has the duty to consider Section 55 of the BCIA 2009, the best interest of a child, the courts found that in that case that I was talking about earlier, the best interests of the child has not been considered when the fee is concerned. And this is interesting because we're effectively talking of children who are entitled to become British. It's not as if they will be granted limited leave after the application. What about the fee? Well, currently there are no fee waivers for such applications. And because the case is currently still being appealed, the Home Office has not reviewed their fee. It will be interesting to see the outcome in that case. I made such an application for a client about a month ago, and I am now considering writing to the Home Office on behalf of my client to see if the Home Office will consider a partial refund or maybe a prompt to service instead of making a child wait for another 6 months or longer to become a British national. I will keep you updated on this. Next week, I will be doing a video on the same topic on how to make such application, children rights, children applications, if you have children. And so do watch my video and I will keep you updated. Thank you for watching Kareesha Law. Hit the notification button if you don't want to miss any of my videos. Goodbye.